warm welcome to all the distinguished speakers for this exclusive session. On behalf of BCIC, we welcome Mr. Venkatraman Sir, Additional Solicitor General of India, Mr. P.V. Srinivasan, Advisor Wipro Limited, and Mr. Ashutosh Dikshit, partner Deloitte Tomatsu India Limited. We express our sincere thanks, sir, for accepting our invitation. The session is organized under the aegis of Direct Access Expert Committee, and we also acknowledge the sponsors of the session, Mrs. Bueller, Fundamax, Wipro, MTR, and Sona Group of Companies. Thank you, sponsors, for your support in the initiatives of the Chamber. Now, I request Mr. K.R. Shekhar, our President, to deliver the welcome address. Over to you, sir.
Thank you, Rupa. At the outset, on behalf of Bangalore Chamber of Industry and Commerce, on behalf of me, I heartily welcome my dear friend and learned Additional Solicitor General, Mr. N. Venkatraman, for this. He has been a great supporter of Bangalore Chamber of Industry and Commerce, and he has addressed various programs and seminars in BCIC. As PVS was mentioning earlier, it was proud to have him as amongst us. Now it is a privilege to have him amongst us. That's the only difference. He has been part of our fraternity for ages, and then he became Additional Solicitor General, a very well established, reputed lawyer on direct tax and indirect tax matters. Above all, a great spiritual person. Sometimes the spiritual knowledge and the tax knowledge makes him a little bit wonder. It makes him to do certain wonders, like what he has done in Supreme Court judgment on reassessment. Maradona got a benefit of hand of God after he defeated England. He said that hand of God helped me. So hand of God helped the government through Mr. N. Venkatraman on this 147 assessment. Otherwise, what would have been an absolute lost case for the government? Thanks to the hand of God through N. Venkatraman, the government got the reprieve of the Supreme Court in 147. The subject is a very, very heated topic. There has been a views, what I would call a different views, with a lot more emotions on both sides. I would say emotions. Normally, emotions are less in tax rulings, but this is a one ruling that has created so much of divide between the taxpayers, fraternity, the councils, and everybody. Let me just give an introduction to the subject, then I will leave it to Mr. Venkatram, PVS, and Ashutosh Dikshit to articulate it. The entire scope of 147, right from the old law, has been a matter of a litigation. Under what circumstances reassessment can happen, under what circumstances reassessment cannot happen, what is the power of the A1 to the reassessment has been a matter of great litigation. Very cold express newspaper made it very clear the C&AG audit report cannot be the basis for reassessment, then that got amended. Then the entire reassessment procedures was proposed by Supreme Court in GK and rulings. That is being followed, but still there is a lot of issues on the reassessment. And we, the taxpayers, have been generally saying that the reassessment has to be restricted only in certain select cases, not in every cases. For every amount, the reassessment notice cannot be reissued. It should be only on select cases, only if there exists a serious tax evasion, not on a similar or not on issues where 154 can be resorted. The government came out with an amendment, entire reassessment amendments in Finance Act 2021, by which it was stated by the Honorable Finance Minister while proposing that bill that this reassessment is meant for those taxpayers where the tax evasion is there and more than certain limit. Basis that the amendment was proposed for more than 50 lakhs in certain cases and less than 50 lakhs in certain cases. And we all believe that the notices should be under the reverse section will be issued only in certain select cases. But meanwhile, there was a COVID and the government came out with an extension of the rules for issuing of notices. Taking advantage of that, the department issued reassessment notice under the old section, though the new section is operative from 1/4/21. Taxpayers went to the High Courts, Allahabad High Court, barring Chhattisgarh High Court, all the High Courts gave a Bombay High Court, Allahabad High Court, all the High Court, Delhi High Court gave a ruling in favor of the taxpayers. Matter reached Supreme Court. Now, Supreme Court in its ruling, first time I have seen where they exercise jurisdiction under 142 for the tax purposes, 142 of the Constitution for tax purposes. I wish Supreme Court exercises jurisdiction in most of the cases where there is enough refunds of the taxpayers are pending on DDT, most favored nation clause and other time. I hope Supreme Court will exercise the same jurisdiction. Supreme Court came out to the reconciliation approach, stating that, and I'm amazed by the wordings of the Supreme Court and the reasoning. That in due respect to the Supreme Court, Judge, Honorable Lordships and Justices, they said there is a bona fide mistake by the department of issuing more than 9,000 notices. By mistake, they issued a notice under the old law. And I'm still surprised how can there be a mistake by so many officers, so many commissioners. I can understand if one or two officers issue notices. There is roughly around 90,000 notices have been issued. That means every IAO and every commissioner has made a mistake. And as per the reassessment notice on the board section, you should need to get approval of the commissioners. And commissioners are given the approval without knowing the law. I am surprised to hear that. Second, how can the board keep quiet when so much of commissioners have issued a notices without knowing the law? And what is the board response to that? And now what the Supreme Court said? What will be the mistake is fine. Now all the notices can come under curative law under the new sections. All the defense available to the taxpayers are also now available. First of all, I am unable to accept the rationale of notices which are not valid, and Supreme Court curated that notices by stating that these notices can come under the new law. When the notices are issued under the old law, when it is struck down by all the high courts, it is incorrect. Supreme Court says it is by mistake, the genuine mistake they have done, and therefore 90,000 notices have got a life. Fortunately, CBDT has given a clarification that for the 3 years, less than 50 lakhs, they will not issue the notice. I hope it gets implemented the letter and spirit. The second challenge of the Supreme Court ruling. The entire purpose of 148, 140, the new assessment is only for the cases where there is a tax evasion. That was made out very clear by the minister while passing the bill. It was made out very clear subsequently. When there's a very clear case of a tax evasion, though the section says you need to give a material, you need to give a report to the taxpayer on the basis of issuance of fund, they need to file a response. All the procedures are there. But why notice? How can a notice be issued just like that under 140, even a new section, and there is no case of tax evasion? I'm unable to appreciate the logic. Third, exercising the jurisdiction. I'm not a constitutional expert, but I'm going by the reading of the judgment and the facts. Exercising a judgment, bringing 142 of the Constitution and dealing it under 142 of the Constitution for this matter, for tax matters. First time I'm hearing it. There are enough provisions in the law, there are enough cases of the tax laws before the Supreme Court. For whether for this reassessment, can a 142 of the Constitution be invoked is a moot point. As I said, I'm not a constitutional expert. I leave it to lawyers like Mr. N. Venkatram to articulate whether 142 of the Constitution is required for these purposes. Essentially, Supreme Court has sat on the arbitration reconciliation matter on issue of notices in 147, in my view, which has exceeded the jurisdiction of the Supreme Court, subject to the legal pundits like Venkatram correcting. Can a Supreme Court matter before the Supreme Court was that whether notice is valid or not? Supreme Court ought to have answered that notice is valid or notice is not valid. But Supreme Court went beyond, says notice is not correct, but however you can issue it under the new section. I do not know whether the Supreme Court has exceeded its jurisdiction. Leaving aside all these things, the implication of Supreme Court judgment, and I'm worried about this because this can be called as a precedent in other cases. I do not know how much it will have a precedent value in all these matters, subsequent judgments. Leaving this one side, CBDT has issued a clarification. where the clarification, there was before CBDT clarification that's available in the public domain. The entire commissioners of income tax, Royal India Gazetted Officers, commissioners of income tax filed a detailed note to CBDT. I am not so sure when I went through and I compared the CBDT clarification, the representation made by the gazetted officers. I am not so sure whether all the points raised by the department officials have been clarified by the CBDT in its notification. CBDT in its circular made it very simple, as if the entire Supreme Court judgment is answering only on two things. They said before 3 years you don't do it, after 3 years you do it, and they divided into three categories. And subject to all these facts that under 149, whether even if it is issued beyond after 3 years for excess of 150 lakhs, whether the new provision section 149, whether the department will have any leeway for that. When I'm coming to leeway, I am once again expressing the Supreme Court said that in its judgment, we need to give a leeway to the department so that all the 90,000 cases we need to find a way out. Leeway to the department on what purposes? I have no idea. Anyhow, as a professional, I have my own views on Supreme Court judgment, and the CBDT has tried to make amends. The only point that I'm keeping on saying as a professional and as a chamber president, the entire scope of reassessment should be restricted only in certain select cases, only in the cases where there has been a tax evasion or there has been a what I would call a conscious and intended concealment by the taxpayer during the assessment, not with an intention for the department to play a second innings on a match which has already concluded and the results have been announced. If we started giving this sort of a teeth to the department, litigations will continue to increase. Once assessment is completed 143.2, it's done and dusted. No point in reopening the reassessment except if found a material that enough material to say there's a tax evasion. And above all, using this measure for the small taxpayers is unwanted, and genuine taxpayers should not be put into difficulty. I'm happy CBDT in its clarification that less than 50 lakhs for the first 3 years should be there. In fact, I would like to say that less than 50 lakhs should not even come into reassessment because the time that it takes is very, very high. I think that's one way we should look at reassessment as a overall objective. Anyhow, I stop over here because I can keep on talking about the judgment and the implications of this for hours together, and I can have a friendly banter with my dear friend N. Venkatram on this matter. But I would like to leave it at this point of time. We have a great professionals, Mr. P.V. Srinivasan, who has got a phenomenal experience on tax matters, and we have Ashutosh Dixit, who is the former ARS who has been who was I don't say was the only brain behind, but it was one of the brains behind the direct tax code, and he has got a phenomenal experience in the department as well as on the uh, tax representation. I leave it in the hands of PVS and Ashutosh to interact with Mr. Venkatram on the subject. Once again, thank you, Mr. Venkatram. We can have this friendly banter even offline on this 147, what you have done. As I said, your hand of God has helped the government. That's all I would like to conclude it. Thank you, sir. Thanks a lot, PS. Thank you, Ashutosh, for that. Thank you so much. Back to you, Rupa.
Thank you, sir. Now, we request Mr. Venkatraman, sir, to deliver his keynote address. Over to you, sir.
My dearest PVS, Shekhar, and namaskarams to Ashutosh, Sunil, and the team. I would like to take more questions rather than speaking on this subject, but briefly I'll touch upon the concerns raised by Shekhar and then take questions, because we had a fairly long discussion on this in the Tax Truth Conclave, and a lot of people have participated in that. So I'm interested here to face more questions rather than trying to express my views. I'll take about 10-15 minutes, not more than that, because misconceptions, wherever it exists, there is a duty, more importantly, in the law officer's role to clarify it. So I want to clarify some of the misconceptions highlighted in the introductory note. One, the assumption that Article 142 has been invoked for the first time in a tax matter is not the correct assumption. It has been invoked several times in the past. More importantly, in favor of the assessee. Justice Rumapal in synthetic chemicals, Justice Sikri in the photographic matters. So, see, how did 142 come into picture? We should all, what is the genesis, starting point of one? Today we use it for very abundantly in various places to fill vacuum. It all started with the doctrine of prospective overrule. That's the genesis of the starting point of 142 in India. 11 judges in Golaknath. When the law declared by the Supreme Court will travel back in time as justice in rem, 11 judges said, in a given circumstances, even though we pronounce the law, and even though law naturally travels back, we can say this law will travel back, travel henceforth only into the future, and past can be protected. A perfect U-turn in jurisprudence. This is the power under 142. I'm saying all this to only explain. Every judge who wrote about 142 has said, don't tinker it with any limitation. There is only one limitation in 142. Like any other constitutional organ, like the legislature, parliament, and the executive, and the judiciary, it is left to the constitutional trust and discretion of the judges who want to invoke this doctrine. This is the elementary and fundamental principle of Article 142. You cannot ring fence it in any form. It's left to the constitutional trust and left to the constitutional discretion of the judges. That's the unique power. You can certainly comment on it, criticize on it, express on it, talk in favor, all that is fine. But to say that it should be ring fenced is incorrect. Several times this has come, it has been rejected. Therefore, it is not for the first time this is invoked. It's the first clarity I want to give. And two, Shekhar expressed a view, what is all this Supreme Court is saying, bona fide mistake? How can there be a bona fide mistake? There is a lot of difference in law between ignorance of law and committing a bona fide mistake in law. There's a lot of difference. Ignorance of law is not excusable, whether it's by the assessee or by the revenue. But bona fide mistake is not something which falls under that category. What do we mean by bona fide mistake? That's the point. See, here is a case. You had an old law till 31st March 2021. And you brought a new law on 1/4/2021, extinguishing the old law. From April 2020, you have been extending the time limit of the old law every 3 months. And you also extended it on the 28th March, notwithstanding extinguishing this old law. You extended it up to June 2021. There was a notification issued on 20, as you brought this new amendment, there is also a notification issued. So the question was whether in the given defined circumstances, whether the old law will apply or the new law will apply. Please remember, several high courts have gone into this issue. 10 high courts in your favor, assessee's favor. All the high courts heard the matter for days. Arguments were presented on both sides. Revenue councils fought it very valiantly with their own principles, with their own doctrines. So, what made the court finally decide or resolve the issue? It said it accepted assessee's contention. I want Shekhar to understand that. All the 10 judgments approved assessee's point of view. What is assessee's point of view? This law is nothing but a procedural amendment. And because it is a procedural amendment, it can travel back in time. The revenue's case was, no, This is a substantive amendment. Make it prospective. Allow us to use the old law for the whole period. Rejected. Squarely rejected. So the question was whether it's a substantive law or a procedural amendment. It's not some magic wand. In one day you will decide it this way or that way. It was argued court after court. So having decided that it is procedural law, that is why it was allowed to travel back. Now, when you travel back to the past, to say, A, it is procedure, B, you can go and penetrate into the past. However, all notices issued under the old law is defunct, faulty, inexcusable, unpardonable, and therefore assessee revenue should be without remedy, and therefore let all 90,000 notices should be dropped, is according to the Supreme Court creating a vacuum, having held it procedural. That's the line. It is not without any basis this was given. It was not just given for the asking, it was fought. So when you say it is procedural law, what is the jurisprudence on procedural law? Same Supreme Court in tax matters, starting from the Atiyabari case of Justice Sabyasachi Mukherjee, one of the greatest Chief Justices, greatest tax judge, has said procedures are handmaids of justice and not its mistress. It has enormous flexibility. So, A, it is procedural. B, it can travel back. And therefore, Supreme Court took the next step. Once it can travel back, wherever notices have been issued, it did not give right to issue a fresh notice. Then you can argue. Wherever notices have been issued, because there is a high test, we are now interpreting the law. In Para 7, Supreme Court upholds the judgments of the High Courts holding it to be procedural. It upholds all the High Courts to be right and says, makes the next step, having held it procedural, we can't create it vacuum or render it remediless. These shall be construed. Having allowed the law to travel back, we should also allow the notices to be read as deemed to have been issued under the new law. What is wrong? So you will allow the law to travel back in an interpretation and drop a bombshell. How is this an unfair judgment? I want to know. To term it as unfair, to term it very critical, what is the basis for that? There's no basis because you argued it's procedural and you succeeded. We only built from where you left. We did not create a new structure in this case. It was not we did not create the foundation to this case. We only built on your foundation. Or else agree it's substantive, then allow the whole law to operate. Either of the two should operate. So this was one of the reasons which Supreme Court says, therefore bona fide. It is not ignorance. When you are confused, when it required an interpretation by courts to decide whether it's A procedure or B procedure, having resorted to one procedure will qualify you to say it's a bona fide mistake. Having not issued any notice is not bona fide. It did not say 90,000 notices you can issue today. It's a bona fide belief you kept to yourself in tapas and thinking which law to wait. You are waiting for the judgment. It did not say so. It never said so. So this is the basis or foundation for this judgment. And I have not seen one opinion or one article out of this 500, 600 articles saying this basis is incorrect. Not one. Now, third. Now, will this become a precedent? An 142 order can never be a precedent because it is constitutional trust and constitutional discretion. There is a difference between, because you are saying, where is the equity in tax law? That was one of the questions posed to us. Equity is a principle tested qua assessment and qua an assessing, not qua an issue. Then how did synthetic chemicals waive the past taxes? How did photographic case waive all the, after holding the law against the SSE, it waived the taxes. It held the law against the SSE. It declared the law against the SSE and said past taxes need not be paid because it's a bona fide mistaken understanding of the whole trade. So there it is a bona fide mistake, not ignorance. Whereas when officers issue notice, no, it is not a bona fide mistake, it is ignorance. How is this? How does this match? So it doesn't create a precedent value. 4. All right, it's all 148A, fine. But how can you read TOLA into it? Simple. Very, very simple. Look here. In 2020, 1st April 2020, you did not have 148A. You had only the old law. And you kept extending the time limit of the old law through TOLA. And what does the judgment says? 1/4/2021 law is procedural and it can travel back. So you will disarm the revenue. You can go back for those years where you actually can do a 148 under the old law, but you will be disarmed. You cannot use TOLA. You are lost forever. Then what are you trying to say? You are actually frustrating 2 assessment years to be not done a reassessment at all, either under the old law or under the new law. Which court will uphold this plea? In law. A frustration is never acceptable in jurisprudence, especially when you read the law to be procedural in nature. So when you travel back in time for the past, then whatever is the law for the past as extended will apply automatically. We will apply for the past, but not go by. So it will result in vacuum. That's not the intention. That's why Supreme Court in one sentence said it shall be construed to have been issued rightly under 1/4/2021. To fill all these vacuum, it's deemed to have been issued under 1/4/2021. So, and the last question, because somebody wrote an article from Bangalore, I happened to read it. It says it's all fundamental right is violated by Supreme Court by invoking 142. Right of appeal is not a fundamental right. It's merely a statutory right. So there is no fundamental law violation or any such assumptions to make at this point of time. See, 4 things have fallen into place. The budget speech of the FM, which said, this is what we want the law to be. The exposition of the speech by way of an amendment by the Parliament. A judicial interpretation of the Supreme Court bringing the law, the interpretation in sync with these 2. And you can believe at this point of time, the icing on the cake is the clarification issue. I can tell you one thing in a very, very responsible way. Board consistently has been extremely fair and neutral in this matter. You can remember, all of you in the trade can remember, we brought 6 amendments in this year, retrospective amendments in this budget. 6 amendments, including getting over tribunal rulings. It was a conscious call by the ministry that we will not amend this law retrospectively. We could have done it. 10 high courts are against us. We said we should only plead before the Supreme Court and argue it on this point. We should not amend it and create an inconvenience to the trade by taking the law back to the same force for the whole period. Let's not do it. Let's wait and see how Supreme Court responds to this. So we could have very well gone through the legislative road, which we didn't. And 2, after the judgment, the biggest fear everybody had was all 90,000 notice automatically will get confirmed. See the circular. It has come out openly. 3 things. These following 3 years, if it satisfies the new regulation, please do not even give materials. These have to be dropped. Don't even supply it. How will the proceeding start? Because there is a mandate by the Supreme Court. You have to give the materials within 30 days. The circular says, don't even furnish materials. There's no need because we don't want to waste time on these proceedings. Wherever it has to be dropped, should we invite an objection? So they're looking at a mechanism how to close it. That is all. That's why they said we'll come back to the circular. It is not to reopen the Pandora box again. That's the understanding we have, all of us have at least from our end. And two, for the first time, very boldly the clarification says, nobody now can say my boss has said, no ministry said, no board said, they can't plead. It says wherever there is a satisfactory reply, please drop it. You may issue an order under 148 AD and communicate and close. Please see the last bullet in that circular. So somebody cannot come and say, no, I had a pressure. Nobody is pressurizing anybody. Be fair. See, this is a very good initiative from the ministry. Because enough deliberations, we have come to this stage. We would request the trade also to respond in a very sportive way, where there is a case to be made out. I hope it will be made out and fought. So you have two filter points. Straight legislative filter point, less than 50 will go for 3 years. Second filter point, if you are giving a satisfactory reply, at least the circular says your hand, the officer's hands are not tied. He is entitled to drop matters. There is no influence or a thrust or a pressure from anybody. Is it not a good, a very good initiative in letter and spirit in respecting the Supreme Court judgment? So these are the takeaways I thought I should leave on behalf of the revenue. I'm ready to take all the comments. No problem about it. We are used to that now. I'm at least used to that for the past 2 years. But you should also know we are also moving in a different direction. You should also trust us and you should also work with us. That's these are the few things in the 15 minutes I thought I should clarify. Otherwise, we have spoken about it in length in the earlier meeting. I'm more eager to learn from you and learn questions and see whether I can answer together or at least at my end. Thanks so much for the
Thank you. Before we request PB and Ashutosh to ask the questions, I just wanted to respond to 2 things. Number one, while you and me can have a debate on 142, validity of 142 on this, which I don't want to get into this arena. We'll have a separate debate on that side. But 2 points. Number one, while we welcome the circular, CBDT circular on mitigating the notices and giving the requesting the officers to drop the matter if they are not found satisfied. They are found satisfied with the response of the AO. I hope it gets implemented in letter and spirit at the field officer level, because past experience, you always said trade should cooperate with the department. We have been extremely, for example, day for yesterday, we had a session on TDS with the Chief Commissioner of Income Tax. We were told Bangalore has become the number 2nd in the all India tax collection, surpassing Delhi. So the taxpayers have been extremely cooperative. We wanted only the genuine hard payers, genuine taxpayers should not be put into harassment by the circular. That's the only plea we are having. We are not defending the dishonest or disgruntled or illegal taxpayers. We are not here to defend them. Our only plea as a chamber and me as a professional is that the genuine taxpayers should not be put into difficulty. Number 2, I hope this is a message which I would like to give it to Mr. Venkatram as an officer from the revenue. Please request the officials to implement the circular in letter and spirit at the field level. And very often we have seen in the past as well as in the future. For example, the entire e-assessment, what was intended as a well-intended measure, has completely thrown the system into difficulties. Completely thrown. In fact, we came out with a detailed booklet on the challenges on the e-assessments. So the past is not a great sign for us to do about it, but I only hope that this circular is implemented in letter and spirit. That's the only 2 comments that I have. I request PBS and Ashutosh to take it forward.
1 minute response. Very fair, very fair. I would only request the BCCI and anybody for that matter through a proper body. If you can highlight, see, if you can really highlight, these are trade issues. These are the real bottlenecks.
Sir, on e-assessment, we have highlighted the issues. We have submitted a detailed report to the CBDT, the Ministry of Finance, if required. We will send one more. We'll send a copy of the report to you.
Please send it.
What
Please
are
send
the challenges from the e-assessment? What are
Please.
the challenges tax administration? Rupa, please send our entire direct tax reform
Please.
report to Mr.
We'll see
Venkatram.
what
Yes,
else.
sir.
See,
We have brought in
GST.
brought in-
1 minute I can
we-
assure you, in GST there is a huge problem on Tran 1 for the past 5 years. Post vacation, we have told the High Supreme Court to post all the matters post vacation. The board has a rethink on it. We are going to solve the problem in July.
Very good.
So we will try to see what best we can do.
Absolutely.
Anything genuine, no problem. Because you must also understand, Mr. Shekhar, from our end, having worked for the revenue for 2 years, there are 2 sets of cases which come before the court. Genuine assessments which needs to be dropped sometimes don't get dropped. Likewise, in some cases, not in all, ingenuine assessments which needs to be confirmed also gets dropped, resulting in a 263, resulting in an IT80. So it happens. No, you must understand. I mean, when we do the matters, it's a now I'm seeing both sides. Therefore, I can share my experience.
Okay.
So it's not white everywhere. There are areas of gray. So
I agree, sir.
within that, the board and the ministry, at least the team now for the last few months, extremely time bound, extremely sincere, and they respect, they know, because we are not able to get away from courts anymore. They come on us if we try to commit a mistake. Courts are now more favorably disposed to assessees than to revenue. So these are the timelines in which we work. So we have today a very, very responsible team. I should say that. Otherwise, this order could not have been achieved in the Supreme Court. The kind of support within the limited window time we had, we got it. So we will try to do our best, whatever is possible in law. That assurance I can.
Sure, sir. Thank you. Over to you, PBS and Ashutosh.
Sir, this is a reverse equity question I will try to pose to you. All of us are saying that it has been very generous to drop cases of 50 lakhs. The officers felt it is the old law which will apply. Under the old law, only 2 lakhs was applicable, not 50 lakhs. That means the department is willing to give away all those cases which they thought is good and collect revenue, but now they are willing to drop. Will the board come out with a circular that every taxpayer will be given a relief of 50 lakhs?
No, if you see the para 7, we have seen it's a commitment we gave to the Supreme Court. Right? Let me tell you the background for this circular. Because that was one great apprehension expressed by the counsels who argued for the assessee. See, you are now deeming these notices as issued under the new law. But take it from me, all 90,000 notices will get confirmed under the old law using this mechanism of Supreme Court judgment. That was the fear expressed.
No, sir, my question is reversed. I'm saying the concession which is given up to 50 lakhs ought not to have been given, because you have actually prejudiced those assessees who have paid taxes, disclosed income, and paid the taxes properly. Now you say what was assessable up to 50 lakhs, I will waive.
No, but see, it's simple. Answer is this. In enhancing a threshold is a matter of policy priority. It has nothing to do with the judgment of the Supreme Court under.
No, sir, I'm just pushing you back a little. It was under the bona fide belief that they are under the old law. That means they wanted to assess it under the old law.
No. Simple. The revenue officials thought they can assess it under the old law.
So they wanted 2 lakhs limit to apply. All these 50 lakhs cases would have fallen then. What prevented the officers from issuing a notice before 31st March? Because now I feel, as a very honest taxpayer, I have included all my income, paid my taxes, but those who are not included have got away.
Oh, okay. I got your point. See, answer is this. See, I think 142 cannot extend that far to say that. I'll answer it in 2 parts. So that one is the legal answer, another is an answer to your assumption, to your grievance. 142 very clearly says it can only be deemed to be a notice under the new law. Therefore, we have to apply only the new law threshold. Whatever has to be dropped has to be dropped. So this is what 142 is all about. Game is over. And your assumption is officer ought to have issued before 31/2020 or 31/2021 all these 2 lakh to 48, 2 lakh to 50 lakhs, and ought to have passed an assessment order. And therefore, what are you going to do? Well, when you read that this is a procedural law, he ought to have done is something fine. But now the window period collapses with both. See, this is the answer. We can only answer in law because we are now behind time. We have traveled time and we are going back in our exercise. Having crossed that period and having not issued it, thinking that, see, I will reverse it this way. All the officers thought they can issue it under the old law, and therefore they took the threshold of 2 lakhs and they issued it.
Correct.
Now, whereas what operated on 1/4 is only the new law. So you can't push it back in law. Push it back on fact. All of them ought to have issued before 33/30/2021. You had TOLA to extend it. So there again, legislative wisdom thought it fit. COVID time, you extend it. So it has extended it. So you can't pin down an officer to say you ought to have done it on 31st because you had TOLA extending it for 15 months. So, well, somebody has gained out of this amendment is an inevitable legal consequence, PVS. We can't put
my rejoinder to that. It has got great injustice to those people who have been honest.
That's one way to look. I don't deny it, but to assume that it has deprived or it has to assume that dishonest rest of the notices are dishonest assessees, and therefore they should have been caught into the hook on the right time is also equally an assumption, previous, because it is not an assessment order. It's only at the informal stage.
No, but there's it's not a cavalier notice also.
That's right. So we don't know. We don't know. So when law can get decided both ways, an assumption that these notices can only go this way, it's a good assumption. I don't deny it, but it's only an assumption at this point.
So, my suggestion is that the case, the revenue should have argued for defending every case even up to 50 lakhs because it has cost. That was the basis on which they reopened. And now it feels I have been there is an iniquity against the genuine taxpayer.
PVS, this is the answer I can give straight away. We could not have argued that. I'll tell you the legal reason. So all the 10 high courts have held and Supreme Court has upheld in para 7 that this is a procedural amendment. And therefore it can travel back in time. Once it's a procedural amendment, it can travel back in time. An officer who has to issue a notice, he could have done it on 31st one way, on 1st different way. To force him that he should have and ought to have issued only that is, I don't think, legally an enforceable point, especially you are in an era of TOLA which has extended time. That's the catch.
So, okay, fine.
But I do agree. People who have gained out of it unfairly has gained out of it because of the effects of law and possibly the delay in not initiating proceedings before 31st.
So I would urge the government to refund everybody up to 50 lakhs, a tax equivalent of that.
File a mandamus, we'll see. Right.
Sir, I have got one more grievance. I'm just putting it in first person just because it's ease of presenting the case, nothing more that. I have received a notice. I am impeccably confident that not a rupee can be added to my income. I am less than 50 lakhs of addition. The government chooses not to act. The notice has infuriated me, and I am about the 1 crore taxpayer, which Mr. Modi, the Honorable Prime Minister, has lauded as one of the elite club, which is very few in that club. I have received the notice. Now I feel a notice is there. There is no conclusion. I have not been adjudicated. I have paid the proper tax. The department says, I will drop your case having issued a notice that there's a suppression reasonable belief to escape. Now it says, I will give up. I don't want to be give up. I want to be adjudicated. I would like to embarrass the department that you don't have a case against me. Please tell me a way out.
See, this is good. So when legislature extends the threshold and says these people need not be troubled, you say, no, I want to prove my bona fide and then fight with it. Well, it's a challenge against an amendment. I think we can't pitch
No,
it.
sir, again I'm saying the notices were not issued with this new belief. The notices were under the old law that reason to believe, I think you have suppressed your income, you are not furnished, I have got material facts, omission, etc. So with that belief, I have been accused, not with the new belief.
No, I understand. Now this has, see, you must read fact with the development in law. The notice was believed with absolute acquisition that people above 2 lakhs are fraudsters, and so for thousands of notices have been issued.
Correct.
Now the court has construed this, you should deem to have been issued under the new law. And therefore, it puts a cap, a lid, a closure on certain types of notices because of a parliamentary amendment. Now to say that you have embarrassed me by issuing a notice, I can at least tell you in law. This is the answer in law. Issuance of a notice cannot be suggested as an embarrassment, because a notice is in an indecisive stage. It only culls out, because then you are premeditated, you prejudge, Siemens will apply. If a notice is like an order, then your challenge ought to have been, look here, you have prejudged the issue.
Correct, sir. Under the Sun Engineering judgment.
So you are saying that we have not prejudged you, we have only issued your notice. Having issued your notice, you have a chance to respond to say, look here, I want to embarrass you, I'm so clean. Before trying to embarrass the revenue with such a clean reply, the law operates to say, you don't have to even reply, we don't want to now take your case. How can you find fault with that amendment and say that, no, revenue ought to have argued, no, you should allow us to embarrass, you should, no. This takes no one anywhere, PVS. I want to be very honest. In law, there is a closure. And to say, I will still try to embarrass, well, you must think of some alternative avenues to vent your feeling, not through the process of law. That much is clear.
But the process of law has been used against me.
It has not been used against you. So you can't.
Sir, under Sun Engineering, under the old law, issuance of a notice effaces an assessment.
But it is not so in new law, because 148A does not efface. It actually presupposes a process, which according to me, even though it's more elaborate, more concrete and more legislative, in essence, GKN has been embedded into a law with the added mechanisms to it. Therefore, even under the old law, post GKN, it does not directly, even though that there could have been a sentence to say it effaces, it does not automatically efface even under the old law is one view which we can certainly promote is what I feel.
Okay, I leave that question, but both are adverse to the circular. I am saying there is a diverted equity. In order to give a equity for 50 lakhs, I think a lack of equity is there for those who have honestly paid taxes.
Yeah.
See, you have to live with times.
So, on that note, yes, let me jump in. So let me take, the advantage of the fact that I have been both in government and I have actually drawn up 5 finance acts besides the DTC. And therefore, my first is a purely administrative comment. And I do wish that that Mr. Venkatraman, takes this back, because the whole question is that why were 90,000 notices issued? And to that, sir, let me say to you that this is not a new phenomena. This number of 90,000 has come into the public domain because of the Supreme Court judgment and Article 142 having to be invoked. You see, within the department, I don't know whether now the procedures have changed. The information is collected by one wing of the department and assessments are done by another wing of the department. And this so-called information is the wing of the department which collects that particular information. They have so many other things to do. They sit on it. And it's only in the month of March that this particular information, just before the time barring date, because then otherwise it will be on them. Then, these informations travel to the assessing authorities who are already anyway, looking at time barring matters for assessment. And they willy-nilly in all of these cases, it is not a question, nobody wants to take that risk, that, okay, this information is not good enough for this or that, let me ask the SSE. In all of these cases, notices are issued. And let me also tell you that even under the old law, some of the notices you had to take prior approval of your superior officer. Many cases, because these notices were issued in such a hurry, a lot of those, pre-approvals were not taken. And therefore, courts have actually, struck down those notices on jurisdiction. So, sir, my only plea to you is that this particular malady which Supreme Court has tried to balance out, the malady lies in the administration of the Income Tax Act and not in the act itself. So please, if you can carry back this particular thing, some tough questions need to be asked. Why were 90,000 notices issued at all? And whether this is a direct phenomena, because otherwise we will still, even after this judgment, every year the same thing will happen. That is my, input to you, that let us, in the administration of this itself, let there be, much more transparency and much more tightening up so that, we don't end up with 90,000 notices. That is one. Now, sir, let me give you an interpretation of the Supreme Court judgment. Like I said, I was not, there, and you were the one who argued it as well as the other counsels. But according to me, they're using the same principles which you have used, but on a narrower focus. One can still arrive at all the conclusions which the instruction says, the CBDT instruction says, except that travel back, phrase. And let me put it forth to you. The Supreme Court said that they agreed with the High Courts that any notice which is issued after the 1st of April 2021 has to be under the new law, and therefore implicitly recognized that even though there was an enabling act called TOLA, which extended the due date of the old provisions beyond that, or at least it was read to be by the revenue, because the notification was not under the legislature. The notifications were issued by the revenue authorities, who are the executive authority. So, but the Supreme Court agreed that, yes, these are beyond jurisdiction under the old law. But they said that revenue cannot be held remediless. Now, according to me, what they were saying is, and that's what they have said, that after 1421, therefore, the procedure by invoking Article 142, the procedure, I am shortening the procedure. There should have been a 142A1, 1A, but we will deem that all of these are notices under section 144(1)B. So now once that is done, then in all of these cases, they've also given directions about 30 days and, response and all of that, again, shortening the procedure. And then they've said, but the taxpayer can take all the defenses available to it under section 149 as amended. Now, sir, my point is that, my own view of this entire Supreme Court judgment is, I think it is a very fair judgment. I think that they have tried to do the best, in the sense that 90,000 notices and all of this and reissue would also have created another round of litigation, which actually taxpayers would also have, been put to a great agony, besides the revenue, of course. So, but my only point is that, according to me, even reading the Supreme Court judgment, a taxpayer should be able to invoke all the defenses under section 149 once it is responding to these notices. Now, so one of the defenses under section 149 is the first proviso, which says that what you could not have done under the old law, you shall not be able to do under the new law. Right. Which means that which means that as on 1/4/2021, if Beyond that, if you could not have reopened anything beyond 6 years, then in that case, even under the new law, even if the income escaping assessment is more than 50 lakhs, then still you cannot reopen those. So, sir, my reading of the Supreme Court, according to me, that the Supreme Court judgment can be read exactly in this way also, and following all the principles which you have laid down. My only point is that I do not have to I do not have to invoke this travel back mechanism and this additional travel back mechanism, because I don't think the Supreme Court has stated that specifically anywhere. And therefore, my only point is that the taxpayer should be allowed to invoke the first proviso of Section 149, and for those two particular assessment years.
I'll answer it in 2 sentences. None of these 90,000 notices has invoked 10 years. Let me clarify that very clearly, because they were all issued under the old law. So any fear by the assessee, these notices will now become 10 years is an completely an assumption which has no legal or factual backing. So these notices cannot become a 10-year notice. So the proviso one has only limited application. When we have amended the law for the future to say that we can go and travel up to 10 years, because of vested right there, in fact, we could have very well argued this is a substantive law and succeeded also, instead of calling it a procedural law. The first proviso is a clear indication that past assessments are your vested rights. We therefore cannot travel back for 10 years using the new law, and therefore it will be limited only to 6 years. We could have actually argued using proviso 1. See, I never argued before the High Court. I argued only with the Supreme Court, and by that time 10 High Court judgments are. According to me, there is a sparkling point to crack for the revenue to say, if you say it is procedural, then we can invoke 10 years also. There they have protected you through this proviso. One minute. Therefore, it is impossible for past years to go for 10 years. It's a settled law. In this case, this issue is completely academic, because all the notices at the maximum has only invoked 60 years because that was the old law. Now they are being deemed to be under the new notice. So 6 does not become 10 here because there is no notice, underlying notice.
So that is not my, I agree. That was not my question. My point was that under Section 149 first proviso, one of the defenses, which, as you said, is the vested right of the taxpayer, is that what you could not have done under the old law, which is the time period, you cannot go do that under the new law, and it will only be.
I'll answer it. You are simply frustrating the Supreme Court judgment. You can try, but at least I will give a friendly advice to the trading community. So you can keep trying your luck in whatever way. If you are going to frustrate, then we will not this time waste time and wait for 10 high courts to decide. Any such action in any high court, we will move immediately to the Supreme Court only. And because we want to give a quietus to this issue, any amount, anybody can litigate. See, we can't stop you from litigating. But if you think, okay, let's have another 5-year plan out of the assessee's funds and start fighting cases, this is not going to work. We will go back to the Supreme Court and knock its doors, and whatever clarification needed, we'll take it. But remember, any attempt to frustrate these notices, at least I'll give a friendly advice to the assessee, do not waste your time, because interest is costing you. Wherever you can solve issues, appear and resolve it. Get an order. If you don't get an order, move and start fighting the appeal. If you think that you can now play with the courts another 5 years of litigation and think that you will finally succeed, 2 things can happen to you. Courts will come down heavily after a Supreme Court judgment. If you think high courts are going to still say, no, these notices are bad, well, you can live in your own world. We can't stop you. You can do whatever you want to do. It's your best luck. 2, suppose you succeed. The weapon of always using an amendment, retrospective amendment, because we want to implement the Supreme Court judgment. You always have the legislative route. So our advice to the assessees is, leave it to you. It's your option, your counsel's advice, you go by. Please resolve these notices. Wherever it gets automatically dropped, be happy. Wherever you have a fair case, go and fight it. At least there is no pressure. The officer can use his discretion to drop. That's what we have said in the circular also. And wherever there is a bad case, the officer will confirm and you have to fight it in your way with your counsel. Do not try to reinvent litigation. It's a friendly advice. You may listen, you may not listen. That's your choice.
Right. Certainly. And so this is only, of course, a discussion.
Academic. I'm just then I mean, it's I agreed for this because it will be very intellectually stimulating for me, and I'll be in the process gaining something out of all of you. Therefore, I'm not mistaking you, but the point is, an assessee, because I have been an assessee counsel for 3 decades. Anything which falls from a consultant's idea and lips, he or she can take it very seriously. I'm only giving a friendly advice. Try to fight and close the litigation rather than reinventing fresh round of writ petitions.
Yeah, certainly. But like I said, there is, thank you for your elucidation, because, you know, a lot of the nuances of the instructions have become definitely clearer to me. That particular point which I raised is still, for me, is not clear. But like I said, that is an individual, discussion which we have had, and we'll see.
Right. The window of TOLA, the window of computer programming, all this is now answered in one sentence in para 8 of the judgment. It is deemed to have been issued under 148A. Now to reinvent back the steps, this has not been done, that has not been done, this should have been done. You are actually unbundling para 8 of the judgment of the Supreme Court. And if you are confident that you can, high courts are going to say, no, Supreme Court is wrong, Supreme Court judgment is bad. I fear, sir. I strongly fear high courts are not going to say all that. There's a hierarchy, there is a protocol to follow. So yes, once it is deemed, start your mission from there and fight your cases. And we have, after a lot of thinking, you won't believe this circular, we have worked round the clock. We had conference calls at 12 o'clock in the night, early mornings, hundreds of exchange of messages in group. It was not just written like this and issued to you. All of us were in sync that we should do justice to the Supreme Court and justice to the assessee. This circular reflects that conduct. I want the assessee trade to understand it. Tell me one circular in the past where it has said an assessing officer is free to dispose and drop it. The circular says, please see the last paragraph. I want to read it. See, we are having done a good job. Please, you should keep on challenging. Every time you come back, I'm happy. I mean, I don't mind because every day we listen to this in court. It doesn't matter to me, but it doesn't gel well. You must also note that revenue is also a person. The changing type. See, what does the circular say? Please see the last paragraph. If it is not a fit case to issue a notice under section 148 of the Act, the order passed under clause D of 148A to that effect shall be served on the assessee. What more can a ministry do? No, nobody can say no. I'm under pressure.
That's 1 minute.
You have elucidated the statutory right.
Ashutosh, 1 minute. Sir, why we welcome the circular. We welcome certainly the proactiveness by the CBDT in issuing the circular in mitigating the ruling of Supreme Court. And we welcome the circular as a trade body. We welcome the circular of dropping the assessments wherever it is not a fit case under 148. Wherever it is less than 50 lakhs, where we welcome it. Absolutely, we welcome it. We have no doubts about it. And we thank the CBDT. First time I'm seeing a CBDT coming with the circular within 2 weeks of the judgment. Always we get.
See, the minute the judgment was passed, we started having VCs.
I agree with you. So first time I'm seeing a board. First time I'm seeing a board issuing a circular within 2 weeks of a Supreme Court judgment. We are extremely happy about it. We welcome it. The only thing is there are certain legal nuances which we are trying to highlight it. We are not trying to find a fault with the CBDT circular at this point. We are trying to find the legal nuances, what is missing out. And we are also equally finding out the legal nuance of Supreme Court judgment. That's our intention, sir. Nothing. We are not degrading or anything like that. We just want to clarify that point.
Absolutely fine. There is no. I am not taking it personally, but it's my responsibility to say considerable care, considerable effort and time has gone into the circular. So many meetings, so many conferences, so many doubts, so many people wrote to the board with a lot of queries. We had hundreds of questions from the field.
My only request to you, sir.
We
My only
filtered all of them and brought it into the circular.
Yes, my only request to you is that. Of course, Ashutosh will have some more points, and Sunil has got. Please refer the entire plea made by the All India Commissioners. There are a lot of legal points which has been raised. I'll forward that to you in your WhatsApp. Check whether some of those points have been addressed in the circular. That's my only request to you, sir. Though it is by department representation, but I believe some of those points raised by them are important. I just wanted you to check on that. So that's the only point. Go back, Ashutosh. Sorry, Ashutosh, back to you.
No, that's fine. I mean, this is my, like I said, this is my only one because I personally feel the circular is eminently sensible. The Supreme Court judgment is eminently sensible. Like I said, my only point of difference, and this is only that is what our discussion is about, is that I think that the Supreme Court judgment can also be read without using the travel back as a mechanism. That's the only point. And I agree.
I have a duty as a law officer. 1 minute. I'll say how it's wrong. Don't mistake. I'll read the para so that you're clear. Come to para 7. If you have the judgment, I'll read for benefit of everybody. Para 7 and first para of para 8 will make the whole problem. That's a wrong assumption. 1 more. Thus, para 7. Thus, the new provisions substituted by Finance Act 2021 being remedial and benevolent in nature and substituted with a specific aim and object to protect the rights and interests of the assessee as well as being in public interest. The respective high courts have rightly held that the benefit of the new provisions shall be made available in respect of the proceedings related to the past assessment years. How do you say it doesn't travel back?
Sir,
it's my duty. My duty to
understand. According to me, the past assessment years, because the reassessment is only for past assessment years. So therefore, my humble reading, and like I said, could be wrong, is that when it's saying it is past assessment years, it is saying is that this particular procedure will of course apply to past assessment years, and this is a better procedure because in terms of like Mr. Or like PVS was pointing out, this talks about a 50 lakh threshold and all of that. So that is benevolent in the terms of the policy decision of the government with regard to past assessment years. That was
that's right. So it travels back. Now, para 8, what does it say? It doesn't stop there. Para 8 gives the remedy. The revenue cannot be made remityless, and the object and purpose of reassessment proceedings cannot be frustrated. It is true that due to bona fide mistake and your subsequent extension of time by various notification, the revenue issued all that genuine. There appears to be genuine non-application of them. Therefore, we are of the opinion some leeway should be given. What is the leeway? High courts ought to have passed an order construing the notices issued under the unamended act, as those deemed to have been issued under 148A of the Income Tax Act, as per the new provisions section 148A, and the revenue ought to have been permitted to proceed further with the reassessment as per the substituted provisions of 147 to 151, subject to procedural requirement. Now, travel back, it has said. Fill up the travel back, old notices to be deemed to be new notices, and you can travel back. And old notices you are entitled to issue under the old along with STOLA. Now to say it can travel back, it can be old notices to be deemed, but it will be a deemed notice. You see, you can attempt, there's nothing wrong. This will lead to 2 assessment years not being reassessed at all. I mean, try your luck. Courts are going to say, yeah, Income Tax Act, you cannot reassess for 2 years. That's lost. Let some court hold, then we will think whether we should go for a legislative amendment. That's all. So at least we will not leave an assessment neither under the old law nor new law, any assumption that you can get away being unassessed without a reassessment I fear I don't think Parliament is going to accept it, nor courts are going to accept it. It's a friendly advice at this moment.
So thank
Yes,
you.
sir.
I don't have any further question on this, Shekhar. So back to you.
Thanks a lot, Ashutosh. Anybody has got any points? If before, if the, I just wanted to check with the audience here. Tapti, you have anything to add? Murali, anybody? If no, then I'll request Sunil to give his concluding remarks and close the session.
For that, thanks Shekhar, thanks PBS, and thanks Mr. Ashutosh. It was very, very stimulating for me because I volunteered to speak because I wanted to learn from all of you. And
Sir, we will have one more
Thank you.
session exclusively. When you're coming to Bangalore, you, me, and PVS will have a session in PVS office on this matter. On offline discussion. There are a lot of
On a personal note, I feel that a retrospective amendment would have been the best solution. For the only reason, it would have also removed the iniquity issues I raised with you.
but anyhow, that was a policy choice. The
So
government.
I'm saying now there is an iniquity which has been caused, which was not intended by law, but it has been caused by administration.
I think I can't answer it now, but this was a well thought. In fact, we debated you can in this year, even tribunal rulings, a couple of which we have given retrospective amendments.
Yeah.
The Supreme Court concern was
Rate of 10 high
We
courts.
used to have a retrospective amendment only for Supreme Court rulings. And Supreme Court and High Court.
Supreme Court concern was loss of public exchequer. That is what the circular has done.
No, my only hope is that through Mr. Venkat Raman, from next year onward, there won't be 90,000 issues being notices being issued.
That's the best takeaway. In the whole discussion, I should fairly admit that's a very, very sensible point you have brought out. We will carry this homework. And
sir, my one more request to you, sir, as a law officer, please make sure that the circular stays, because we have seen sometime in the past a benevolent circular always gets withdrawn and the new circular comes in.
You don't challenge it. It's my only anxiety.
My only request to you that there are certain benevolent provisions in the circular. Let the circular stay. And two, please.
One thing I can assure you, I don't think they will do all that, because whoever a whole team is responsible. It's not just one person, and all of us applying few days, long hours of discussion, have found ourselves in a common platform.
Sir, I agree with you.
There is dissent in the circular, I can tell you.
Sir, listen to me, only one small submission. While I agree with your passion, while I understand your passion on this matter, the entire 90 subsection 2 and most favored nation clause has been consigned to the dustbin by CBDT by issuance of a circular. A Parliament constitutional provision of section 90 subsection 2 and DTA was consigned to a dustbin through a issuance of a circular under most favored nation clause. Now, 1 minute, sir. Let me complete it. Sorry. The past actions of the board is not given us the confidence that this circular will undergo a stay, and the past actions of the revenue officials has not given us the confidence that they will implement the circular in letter and spirit. My only request to you on behalf of the trade is that make sure that the circular stays.
That is possible. Second is not possible. We can't go and chase officers. It's their discretion.
You need to.
No, sir. There can be a mechanism that if some officer defies the circular still and passes an order as in a mechanical manner, there should be internal systems to take care of that kind of an injustice.
Now, PVS, please let us understand it in law. Even a constitutional bench of a Supreme Court cannot dictate an assisting officer how he should pass an order. Right. So, there again, it's administrative trust. As you have a constitutional trust for a Supreme Court, one who is assigned a role in government, partly his job is based on trust. This is what I have understood in 2 years of my working experience. And trust is a very fluid term. If an individual chooses to breach that trust and trespass and do mistakes, it takes a long time for the aggrieved party to cure it. You are talking of income tax. We are talking of serious provisions in security laws. Security laws, not in commerce. National security laws. We are dealing with, now I'm dealing with all various matters, different branches and different scales. You will see when we are in. Today it's now Supreme Court has passed an order in sedition law, therefore I do not want to speak about it. What is punitive law? What is prevent? This there is. So everybody, one thing the Constitution makes it clear, because you're all intellectuals, I should share this 5 minutes. There are 3 verticals. The Parliament enacts law. The court can only declare a law as constitutional or unconstitutional. Third, when a law is constitutional and there is an abuse of the law by the machinery, courts have to come down heavily on that abuse. See, this will happen at some point of time, PVS, take it from me, because we are heading towards that. We are already seeing such orders. If an officer tries to abuse his jurisdiction in passing orders which are disproportionate to justice, courts are no longer taking it lightly. If you file 5 cases, only 1 case gets admitted and get decided, alternative remedy, all these hurdles are there, I don't deny. But earlier it was whatever an officer passes, he gets protected. This happened in tax law, this happened in criminal law, police action. It is not happening anymore, both for police and for tax officers. So we are reaching an era. Please you should also not challenge every case of abuse. And I would request you to plan it properly. Don't put any individual assessee into peril. A body like BCCI, plot it for 1 year. If you find strange abuses happening, formulate it. We'll see whether this can be resolved administratively. If it is not, then escalate it to the judiciary. The abuse has nothing to do with law. It's a conduct. And it has to be interfered only through a judicial process. We should not mix abuse with law. That's my only request. But nobody can support abuse. For example, in this circular, no officer can now say in this country that, look here, my hands are tied. He cannot plead that, or she cannot plead that. We have put this specifically after conscious deliberation. This is one step forward. Let us see. Let us also see there is a lot of grace and dignity which we have also thought about it in this matter before issuing all this. So I only wish officers also respond in that way. And if you still find abuse, one course correction we'll try, failure which you should get judgments against. Now police is getting it. Police actions are no longer approved by courts so easily. Abusive police actions. You will get it for tax officers also at some stage.
Thank you, sir. Thanks a lot for your comments. We certainly, BCS as a body, we will take your points. Anyhow, after this, I'll request Rupa to send you the entire booklet on assessment. We'll send it to you. Back to you, Sunil, for your concluding remarks.
Thank you, Shekhar. I just had a couple of comments to make on the last 2 points which were being discussed. One which Ashutosh was mentioning, of saying that hopefully the number of reassessments and notices will be significantly lower. I personally don't see that happening anytime soon, because I think it's become a practice for the income tax department to be issuing reassessment notices on every frivolous matter, which I personally also have been affected. I'm sure a lot of other SSCs are also affected in the same manner.
Yes.
And also going back to the point which Shekhar mentioned on e-assessments, having assessment proceedings 2 days before the due date of issuing an assessment order just doesn't give any confidence to a taxpayer that their matters are being heard fairly. And I don't see how after a notice and assessment hearing is done and an order issued is issued within 24 hours. So I think a lot needs to be done from the administrative side. And I would request, Venkatraman sir to, look at some of these things. going back to what, even PVS was mentioning, even if officers are passing, orders in a mechanical manner, I don't think today there is any administrative, system where these matters and officers are taken up and, action is being taken against the officers. And the officers would generally play on a conservative side. And I think that is still being encouraged. So wherever there are being, misuse or mechanical manners in which orders are being issued, it will be helpful to look at where CBDT has an internal procedure where these matters are taken up and also published to the taxpayers saying that, these matters have been looked at and, these are actions that have been taken. That will give a lot of confidence to the taxpayer that the revenue and the department is acting in a very fair manner. So I think, it could be very helpful if these, steps are taken, which will bring a lot of confidence and, work together with the revenue. And I think, and this will help people to be more compliant, is what I would, want to, state. On the topic of today's discussion, sir, like as always, you have shown your brilliance in using the SSE's arguments and turning it around on its head and winning it for the revenue. So many, congratulations to you. While we have our issues, and the concerns that we have raised, but we should congratulate you on, having won this matter in favor of the revenue. And as always, you've brought this out in a very simplistic manner, the clarity that you brought to this judgment, which is fairly complex, looking at, laws which were there, the past and the new and the circulars. And you've done it in a very, very simplistic manner for all of us. And finally, I think what I would want to leave with is what Shekhar said. I think the expectation from the taxpayers is that the revenue will, go through with this circular in a very fair manner. It's good that there has been an objective threshold which has been put of 50 lakhs, because wherever it is, objective, at least the expectation is it will be followed through. And more on the subjective matter, where if there is a satisfactory response being given, it's good that there is this flexibility which has been brought in to drop the notices. Again, a very welcome move. But like they say, I think we'll have to wait and watch and see how this gets implemented on the ground. And that will truly show in terms of the direction in which the department is looking to move as we move forward. Thank you, sir, very much for taking your time out from your very busy schedule and, engaging with us and, sharing your knowledge and your thoughts. Thank you very much, PVS sir and Ashutosh, for, joining in, and Shekhar for, taking us through this session today. And thank you to all of the participants who joined in on a Saturday afternoon for sparing your time and joining us for this nice session. Thank you, sir.
As
Thanks
usual,
a lot,
I
Venkat.
gained the most, and I thank folded arms to all of you. I have gained the most, and
Thank
we'll
you,
try
sir.
to do our best.
Thank you, sir. And as a conventional, we'll be sending a memento to you from BCIC. Though you are a law officer, it is our duty to send a memento to you. So I request, please send your Delhi address. I have your Chennai address only. Please send your Delhi address. So we'll be sending a memento to you, sir.
50 days, after 1 week, next 50 days, I'll be in Chennai. Therefore, send it to Chennai address.
Okay.
I still welcome you to.
Thank
call
you. Sir, with your permission, I need your permission also. Can we upload this in our YouTube, this entire conversation? You being a law officer, I want to take your permission.
I have the mandate from the ministry. I've spoken to them that I'm speaking this, and
Okay.
we are all in the same page, sir. We please one move we have made, and please come out. See what I request, because it's an intellectual body. Please, let's not identify an individual or any such thing. Let's identify the problems. And next step hold, whether internally, administratively, whether we can bring a sync, we will try.
Sure, sir.
Flag issues rather than individuals or assessees. Flag issues, and see how administratively this can be course corrected. We will see whether can we move to the next step. We'll try.
Sure, sir. Absolutely. We'll be happy to do that. Thank you, sir.
Thank you. Thank you, sir. Thank you, everyone. Bye.
Thank you.
Thank you.